Mm. All right, you can go, brother.
All right, peace everyone. Welcome to the Moroccan Post class, Moroccan Post Law, History, and Government class. I want to thank those who are the students who are here, and we're going to be going as I made the announcement. Today's topic is Moorish treaties and consular relations.
Okay, hold on, let me get to this.
This is part one review. So we're going to definitely slow this down today. We have the material on the screen. We have the material on the screen. All right, I have certain things highlighted. This is a part one review. It's important that we do a review, particularly of this magnitude of information, and that we actually have PowerPoint presentations of what is going to be read. So we're going to begin with the questions, because we're going to do is just have someone read all the questions. We won't read one question and answer. We're just going to read all the questions. These are the treaty questions, Shamalakai-based treaty questions, and we're going to have, if I can have a reader, Terrence, you have the questions on the screen.
Yep, I'm getting them up right. I'm getting them up right now. I'm trying to unpin.
Why is Shim outside?
All right, here we go. Switching it over. Turn my camera on. Boom.
The port gets outside, across the street.
Why you outside?
I'm in the park, we get some fresh air.
But we got the background noise. This is
I am
live.
the background noise.
All right, can we get a reader?
Let me have a reader.
Yes.
We have a reader, please.
Yes. Terrence, may you switch it to your screen?
Larger screen.
Oh, you
Can't see it. Yeah.
Oh, hold on, wait a minute.
Now I can see it.
Okay. Oh.
I can't see it.
Oh, you can't see it?
No.
Let me start my video again. Hold on. How about now?
Good. Okay. Number one, does a national of a foreign nation in treaty with the United States enforce the United States Constitution or the treaty between his or her nation and the United States? Number two, when a Moor is detained, where does a Moor's representation come from? A, Moroccan treaty, B, United States Constitution. Number three, who has jurisdiction to hear disputes between a Moor and the United States pursuant to treaty? Number four, how do Moors waive their alienage protection? Number five, do the United States federal courts and state courts have judicial power to decide a dispute of a Moorish treaty? Number six, what is the ruling agreement between European powers and their states pertaining to native Moors in Morocco and the Moors' extended territories known throughout the world as North America, South America, Central America, and Americana, or the political territorial jurisdiction? Number seven, what are the ruling instruments in international law protecting Moorish rights? A, United States Constitution, B, Moorish bilateral treaties, C, international acts signed by Morocco. Number eight, what are the first European nations that entered into treaties with the Moroccan Empire? A, Great Britain, B, France, C, Spain, D, United States. 9, is the United States of America a state created under British treaty? 10, is the ruling power for the what is the ruling power for the United States? A, United States Constitution. B, definitive peace treaty between Great Britain and the United States of 1783. 11, what is the first Moorish nation that granted the United States asylum and amnesty and recognized them as individual states?
All right. Next slide.
What did you finish reading? What's the rest of this here? Consular notification to Office of Affairs. What's that?
I think we go right into the reading.
Okay. Yeah, coming on up.
We'll go back. Yeah, we'll go right into the reading. The Society version. I think the New York Digest. Yeah, is that it? All right.
Yeah, it was only 3 documents here. This is the Hausenstein versus Lynham.
Yeah, all that I gave you, all that we're gonna go right in order.
Yeah, this is it.
The whole 25 pages I gave.
Yeah, this is 28. Yeah, this is it.
All right, no problem. Yes. All right. We have a reader, another reader. If not, Amanda, you would like to continue to read? I can't see it, T, it's small. I don't know what's going on.
Oh, you know,
I'm making it very small. I can't even increase the size.
really.
Yes. I don't know why, but it's not the same as before.
How about now?
Good.
Is it bigger or smaller or what?
I can't increase the size though. I'm tapping on it to increase the size. I can't. I don't know why. It's not shown on a full.
I don't know. I have a full
You may-
screen here, so I'm not
You
sure.
may
Oh,
have
there we
to,
go. I
Can
got it.
anyone else see it?
You just
Okay.
had it.
yeah, because you would have to share the screen.
Yeah, Abdullah, you gotta hit the pin button. Hit the
Mute
pin
your
button.
phone, please. Mute your phone. Mute your phone, please.
Hold on.
Here it is.
Pin button. Good,
Yeah.
thank you. Okay, Moroccan Post Media Law, Government and History class. Moorish Treaty Protection and Consular Relations, Part 1. Review of the August 24th, 2022 class. Moorish Treaty Protection and Consular Relations, Part 1. Major points for Moors. In the Hausenstein versus Lynham case, the court referred to the language in the treaty and not the language in the United States Constitution, United States codes of laws and statutes. Nationality is the primary issue in the Hausenstein versus Lynham case. Hausenstein's change in domicile did not constitute a change in his political status, political allegiance, and political protection to his country of national origin, Switzerland. Judicial enforcement of treaties in the United States jurisdiction. The jurisprudence of Article 6 of the Constitution of the United States Constitution and the power of Moorish treaties. Records and briefs of New York State Appellate Division. Under Article 6, Clause 2 of the Constitution, a treaty of the United States is the law of the land and a rule of decision in every state court. No state may interfere with the exercise of that power, nor may a state hinder the fulfillment of a treaty's aims. United States versus Pink, 315, U.S. 203, 1941. Belmont versus United States 301, U.S. 324, 1937. Where a treaty regulates the choice of law for purposes of deciding specific questions, the choice of any other law by a state court is unconstitutional interference with treaty power. Hausenstein versus Lynham, 100 U.S. 483, 1879, construing Article 5 of this very treaty, where a treaty makes the decision of a foreign court decisive in certain matters. To ignore that decision is also to fly in the face of the supreme law of the land. Santo Vincenzo versus Egan, 284 U.S. 30, 1931. The Swiss-United States Treaty of 1850 gives exclusive jurisdiction to the Swiss assets to the Swiss courts and makes Swiss law as declared by Swiss judges, controlling the disposition of this case. The Swiss law has already been definitively adjudicated prior to the 1958 decree of the surrogate here in issue. That decree was ignored, albeit innocently, by the surrogate since it was not disclosed to him by the appellee here. And we would also suggest in passing that here is a situation where there's really a valid application of res judicata. Schulkel Fuel Corporation versus Nyberg Realty Corporation, 250 New York 304, 165 Northeast 456, 1929. The determination of Swiss law under the treaty by the application of the rule of res judicata is clearly unconstitutional here. Whatever the source of a particular class or rights, once that class is brought within the regulatory and guaranteeing scope of a treaty of the United States, such rights become federal and are no longer local in nature. Questions of foreign law on which such rights turn in the individual case are quote unquote federal questions, which are reviewable anew or at the appellate level and are free of purely local procedural doctrines of proof or appealability. Whatever parts of the decisions of that surrogate in 1957 and 1958 involve a question of a foreign law as it affects rights under the Swiss United States Treaty of 1850, they are reviewable in any appellate court in New York and by the Supreme Court of the United States, not as a mere question of fact, but as a question of federal right. Hausenstein versus Lynham, October term.
Stop there. Shem.
Yes.
I want you to elaborate on this, on what we just read.
All right, let me say something. The reason why the Supreme Court is making decisions like that because they go by old common law, I mean the law of the old European Empire. What I mean, when nations come together, sign contracts and treaties under the ancient common law, all the kings honor the other king's decrees. There's an ancient tradition. Every king that's in power with the signs of an emperor, it goes to his royal library. When a search is made through a record for a dispute, they go to the old archives of the library for the ancient contract. The former king or former emperor or anybody under administrative powers will read that and that become evidence in law, the supreme law of the land. This all the Supreme Court is quoting was already established, well-established law. Now, let me say something. The United States signed the UN Charter. I will break this down so everybody, all the Muslims has not.
Shem, do me a favor. Can you go in front of your house, please? Sit on your porch, sit on your step, please. Shem, can you sit on your step, please?
All right.
You gotta leave the park. You have to leave the park. You have to leave the park.
Now, all right, hold up. Well, got it.
All right. So as he is going back, walk across the street so he can sit on the front of the steps, because it's just too much, which I knew it would be. All right, so anyone have any questions? Any questions, anyone? No. This is this Hauenstein versus Lynham case is a key case, and you'll see as where we read if we go into the case, about 5 or 6 paragraphs we'll read again, and you'll see the United States Supreme Court decision and firm stance on that state laws cannot abrogate, cannot interfere with treaties, as treaties are federal law. So they don't need to be, states cannot legislate against a treaty. states cannot put it in legislative procedures to remove
Oh, you
those
gotta do it.
treaty protections.
Yeah,
What's, yeah? Yes,
you on mute.
yes, somebody who said something,
Abdul, you
who
on
said
mute.
something.
That was Shem.
I'm not on mute. Am I on mute? Can you hear me?
You
Yes,
can be.
we can hear you.
Yeah, I'm not on mute. Yes. Can everybody hear me?
No,
Yeah.
we couldn't hear you before, Abdul.
Yeah.
I can hear you now before
Can
you on
everybody
mute.
else hear me? I'm not, can everybody except Shem hear me?
Yes,
You can
Islam,
be.
All
yes.
right, so I'm not on mute. I know I'm not on mute. So, yes. Hey, Shem.
Yeah, I couldn't hear you.
All right. You might have to go back into the house because this is not good. Can you go back into the house?
Man, I'm trying to get some air, man. All these guys come out with all this noise now. Man, you can't, man, what the noise at?
Can we come? So come as we want to continue this class, brother. Come on, Shem. Let's go, man. Let's go. Let's go. Let's go, brother. Let's go.
Abdullah, Darian
Yeah.
Tucker. So can you give me the exact language of this case again? How's this thing versus who? So I can go back for
You
reference.
talking about the case, the name of the case?
Yes, the name of the case.
It's up there. You see it up there? Howenstein versus Lynham.
Okay, thank you.
Yes, Howenstein versus Lynham. We're gonna read the Supreme Court make the firm stance, and this is not the only case in which Supreme Court has done that. You have Ware versus Hilton, and that was in 1796. 1796, Ware versus Hilton, and that was when Ware versus Hilton was the first case that was adjudicated the 1783 definitive peace treaty between Great Britain and the United States. That's 1796. And there, the Supreme Court made a firm stance, as well as there's other cases that are mentioned on that the states cannot interfere, states courts cannot interfere, states legislators cannot interfere with a treaty. Because this was an issue that the states, this is why the supremacy clause is in the United States Constitution, because what happened was, but this was they're looking at the history that led to why is the supremacy clause in the United States Constitution. That is for the states. That doesn't make, all right, let's make it very clear, because there's been misconceptions about Article 6. Article 6 doesn't make treaty supreme. It already had that. That was the states. If you looking and reading, as Amanda will read, Mashim will continue his analysis, explanation, how the firm stance that the Supreme Court makes in the Howenstein versus Lynham case, that the states have to bow to treaties, because the treaties are supreme and they become federal law.
Right.
So Shem, you want to elaborate? Continue to elaborate on that.
Yes. See, Supreme Court have to protect the interests of the United States.
We need to
By
see your face.
treaty-
We need to see your face, Shem. Show your face, please.
I'm right here.
No, you're moving the camera around. You got to.
Oh, let me get some more light, man. Cause that's why I stay outside, man. Light, man. I gotta take this
Yeah,
thing
you
off, man.
can't stay outside though. You can't stay outside, so that's not so that can't happen. Which I knew. All right, come on, brother. Let's make it happen, brother. Let's make it happen. Let's make it
Right.
happen.
The
Let's make it happen. brother.
reason why treaties are a law of the land because the states is able to go back into the colonies and form a corporation, a corporate state, organization, a community. Now, if the treaty is not declared a law of the land, that means the United States don't have power to be here in the colony territory that was given to the Lord proprietors. So when the Lord proprietors are negotiating with the crown to allow esquires about a charter for the settlers to go back into the colony territory and pay, that way they can become labor. It's called labor. The reason why the treaty power is so important, without that treaty, there will be no United States. They didn't have power to form a constitution. They have power to operate in the territorial boundaries of the British Dominion. So the treaty had to be declared the law of the land in order for the United States to claim sovereignty in Morocco. Because the only one who had the first sovereignty is Great Britain, Spain, France, Netherlands, Denmark. The United States are number of immigrants, people from these principal nations. So the treaties have to be the law of the land. Not only that, it said they won't pay the obligation of contract. So the Supreme Court was only enforcing British common law. There's going back looking at a final fact finding is that when one signed a treaty with a sovereign, two sovereigns, the other sovereign is obligated to obey that treaty. It's a contract, a binding contract. So that's very principle. The Supreme Court is not creating law, it's only quoting what exists already, previous to exist between nations, with France, Spain, Great Britain, and all the European powers going to war. They're into peace treaties, alliance treaties to stop the wars. So the treaties were the thing they entered to stop the wars and respect each other's territory. So the United States acknowledged that the new formed corporate state acknowledged that the British colony acknowledged that the new British colony acknowledged that, therefore that principle and apply this case here. So the supremacy clause don't give Moors the power to enforce the treaty. The supremacy clause just acknowledge all the states, representative, governors, administrative, officials, that treaties are the law of the land. The contracts cannot be broken. No one can pay the obligation of a contract. So in order for them to have be a sovereign here, they have to be allowed to treat themselves. The 1783 treaty with the crown. So treaties are very important. Go back anciently, ancient time. In ancient time, when a foreign emperor entered a treaty with another foreign kingdom or empire, they signed a treaty or decree, a royal decree. What happened is, when a dispute arises between that foreign kingdom or empire that's been given a domicile county to operate in that foreign land, when a dispute arises, the administrative court of that emperor will go to the archives, the record, and grab that decree or treaty to see what kind of relationship they had, what is stipulated in that contract, that agreement, or so they'll go to war. Or so it won't be no, what do you call it? I forgot the word they call it. What do you call it? Scrutiny between the nation party, contract parties. So treaties are some anciently, or decrees, or royal decrees are some anciently that were put up by emperors and kingdoms and kings to respect each other's principle or how they agree to. Now, which is very important is this right here. The boys got to understand, when all the nations of the world, all the nations, treaty nations, got together to sign treaties with Morocco, signed the Act of Algiers, the Holy See, also the Catholic Magistracy signed that too, the Act of Algiers. When they signed that UN Charter, ratified, that UN Charter and that Human Bill of Rights became the law of the land, federal law of the land. Why? Because the president signed it and Congress ratified. So this to the more that's learning. You have to go to international instruments, the treaties, the bills, and the acts. They are the law. They are the contracts. and it got to be forced by a council. Is that even though a treaty don't have a council, any nation at that time signed a treaty to have a council, they have a right to designate a council based on the International Convention. The Council Convention was that every foreign person that's locked up in a foreign nation with a treaty, he's an alien. He has a right to adequate representation of his nation. All the nations signed that. United States signed and ratified. So this is not nothing new. The United States is not creating new law. The Supreme Court only quote an old standard, a principle that's been laid down to European culture. Next question.
No, all right. Amanda, you want to continue reading?
Yes. Hausenstein versus Lynham, October term, 1879. Error to the Supreme Court of Appeals of the State of Virginia. The facts are stated in the opinion of the court. Mr. William L. Royal for the plaintiff in error. Mr. James G. Field, Attorney General of Virginia, and Mr. J. A. Lynham, contra. Mr. Justice Swain delivered the opinion of the court. The efficacy of the treaty is declared and guaranteed by the Constitution of the United States. That instrument took effect on the 4th day of March, 1789. In 1796, but a few years later, this court said, if doubts could exist before the adoption of the present national government, they must be entirely removed by the 6th article of the Constitution, which provides that all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. There can be no limitation on the power of the people of the United States. By their authority, the state constitutions were made, and by their authority, the Constitution of the United States was established. And they had the power to change or abolish the state constitutions, or to make them yield to the general government and to treaties made by their authority. A treaty cannot be the supreme law of the land, that is, of all the United States, if any act of a state, any act of a state legislature can stand in its way. If the Constitution of a state, which is the fundamental law of the state and paramount to its legislature, must give way to a treaty and fall before it, can it be questioned whether the less power, an act of the state legislature, must not be prostrate? It is the declared will of the people of the United States that every treaty made by the authority of the United States shall be superior to the Constitution and laws of any individual state, and their will alone is to decide. If a law of a state contrary to a treaty is not void, but voidable only, by a repeal or nullification by a state legislature, this certain consequence follows, that the will of a small part of the United States may control or defeat the will of the whole. Ware versus Hilton, 3 Dallas 199. And Chirac versus Chirac, 2 Wheat 259. It was held.
That's another case. That's another case that where the Supreme Court, the United States Supreme Court, emphasizes that the treaties are supreme law of the land, and make it very abundantly clear that the states cannot interfere with that. States cannot interfere with the power of treaties. You know, so addressing state laws and like thing that even becomes state law, not only federal law, but state law, municipal law, county. When it comes to in counties and municipalities and boroughs are not superior than the treaties. And so this is, and Shem did a very good job in explaining the principles of treaties being ancient. And so this is why we have to look back. This is jurisprudence. Look at the volume decision where we study and we have done this even when in the law classes where we looked at treaties and even the treaties that I have in the Moors and Masonry, you know, where we need to look at a volume of treaties and the power of those treaties and see how treaties, you know, operate and that the treaties are supreme. The misconception is that the Article 6, conscious Moors have been told that Article 6 makes the Moorish treaties enforceable. That's a misconception. So please follow me. Just please follow me. That you use Article 6 to enforce the treaty. So let's analyze that. So you mean that only way to enforce it is through Article 6? So that means that the president signs it. President signs it doesn't mean anything. President signs the treaty doesn't mean anything. Congress ratifies it doesn't mean anything. President signs it. The Senate ratifies it. That doesn't mean anything. I mean, it's not enforceable then. So you're talking about a self-executing treaty. A self-executing treaty where it doesn't need a legislative act. So when the president signs and Senate ratifies, it becomes law. You don't need to say that the only way you can enforce it, the only way Moors can enforce the treaty is through Article 6. There's something wrong with that. When you as Amanda continues to read, that the Supreme Court makes it very clear that the states are already bound to it and that they cannot make legislation to remove the obligation of treaties. Shim, are you with us?
Yes.
You gotta put, don't put your don't.
Absolutely right. Because
All right.
I'm a further elaborate on this. Now, when the rebels colony, the subjects of the crown that fled the colony with the war against the Lord proprietors, something happened. When they was allowed to go back in the colony charter, that treaty became the law of the land in that colony. Remember, Great Britain is the law of the land, the British law, British Empire, or the British common law is the law of the land of colonies. When the United States went back into the colony land, they had to put the supremacy clause in there for a reason. In order to be there, because the colonies could not go against the crown. Therefore, that was put in there because the Esquires voted there because the Lord proprietors knew that they could not even go against the crown. So the subjects, when they was given power to go back into the colony territory, under authority of the Lord proprietors, who created a new system, the Jubilee, the states could not challenge the British Empire or British Dominion, the King Law, that treaty. The treaty had to be the law of the land because the United States is only allowed to form that new corporation society based on a treaty. So that way, anciently, when the colonies was existing, the colonies could not go against the British common law. If the crown made a decision or proclamation or decree, it was the law of the colony, period. No individual colony could go against the British crown or the Lord provider, period. So you see the supremacy clause only going by ancient common law. I'm demonstrating to y'all. Under colony charter, the Lord providers, colony charter is given by the King of Great Britain. No law provider or colony could go against the British common law and the British in England. So therefore, if one colony was allowed to go against the British common law or the decrees or proclamation of the king, then that would destroy the British authority, the colonies. So when the Constitution was written, the Supremacy Clause was only a common law reflection of what the colonies couldn't do on the British common law. You understand? I'm trying to break it down so you see what's going on here.
Yeah, definitely. Any questions on what Shim said is that he's making he's drawing a correlation of the British crown in the British colonies and the authority of the British crown, and that in the decrees and proclamations made by the British English/British crown, and that the colonies would that those decrees, royal decrees and proclamations were to be supreme authority law for the colonies. So he's drawing a parallel to the treaties, drawing a parallel to the treaties and the royal decrees and proclamations being the supreme law. So this is a concept of jurisprudence. He's looking back.
Darian Tucker.
Yes.
Okay, so in Article 6, when it says that any treaties made by the authority of the United States, that authority of the United States is Great Britain.
No, let me explain that. See, when they was allowed to go back into the colonies, they was allowed to create a Congress, an international organization, the states, from one central government. They formed one central government. Under that one central government, it became the monarchy of all the states. Meaning that the states every state send forth a delegate, representative to that central body, form that central body. When they send that representative there, he becomes an ambassador to the new formed state. That one colony, the colony consolidated to one solid corporation, corporate state, corporate nation.
Yeah.
Well, all of a sudden they representatives to that one central body, they're like ambassadors, they represent the state. So therefore, when they sign, they got the authority. They're called the what do you call that dude? They call what's his name? They call him, excuse me, I forgot. What's his name? They call him Abdullah with a king, or somebody send somebody. We call it potentiary.
Minister plenipotentiary.
A minister plenipotentiary. The representative of the state, a minister plenipotentiary representing the state. So you create one federal government, one central government. That authority, that the central government was given that inherent power by the Lord Proprietors. Because under the old colony charters, the Lord Proprietor was the one that elected the Congress. They elected the commissioners, the judges, and sometimes the Lord Proprietor became the governor or the elected governor. So the same power the Lord Proprietors had, they gave that inherent power to a central government called Congress, the Senate, the legislature. So the inherent powers in that central government is in the Constitution. So all inherent powers are being in Congress. Our Congress, all the inherent power, so that's a central government. So that
Okay. Understood.
Yeah, yes.
All right, continue, Amanda.
Okay. In Chirac versus Chirac 2 Wheat 259, it was held by this court that a treaty with France gave to her citizens the right to purchase and hold land in the United States, removed by the incapacity of alienage, and placed them in precisely the same situation as if they had been citizens of this country. The state law was hardly adverted to and seems not to have been considered a factor of any importance in this view of the case. The same doctrine was reaffirmed touching this treaty in Carneal versus Banks 10 id 181, and with respect to the British Treaty of 1794 in Hughes versus Hedward 9 id 489. A treaty stipulation may be effectual to protect the land of an alien from forfeiture by a state under the laws of the state, or verse Hodgson 453, by the British Treaty of 1794, all impediment of alienage was absolutely leveled with the ground despite the laws of the United States. It is a direct constitutional question in its fullest conditions. Yet the Supreme Court held that the stipulation was within the constitutional powers of the Union. Fairfax's versus Devises versus Hunter Lisi, 7 Cranch 627, and see Ware versus Hilton 3 Dallas 242. Opinion of the Attorneys General 417, Mr. Calhoun, after laying down certain exceptions and qualifications which do not affect this case, says, quote, within these limits, all questions which may arise between us and other powers, be the subject matter what it may, fall within this treaty-making power and may be adjusted by it. Treaties on the Constitution and Government of the United States 204. If the national government has not the power to do what is done by such treaties, it cannot be done at all, for the states are expressly forbidden to enter into any treaty, alliance, or confederation. Article 1, Section 10 of the Constitution of the United States. It must always be borne in mind that the Constitution.
Let me stop you there, Amanda, for a minute. All right,
No.
Shem, I want you to address conscious Moors for over 30, 40, 50 years, going into traffic courts, state these, and yeah, just address that. Just address that matter. I know we're gonna get more into that detail, all right, but I want you to address that in concert with what Amanda has read.
Okay, let me explain. So now, in order for United States, we go back and she read something, go back, I'm gonna bring it up to what you said, Professor. Amanda, what you read was that in order for the United States to sign a treaty with Great Britain, there had to be a central power government. Once Congress signed that treaty and ratified, the president signed it, therefore that central government had all the power that the Lord proprietors had in the colonies. That central government carried that same power as if they were the Lord proprietor. That Congress now becomes the Lord proprietor. He's discretion as the Lord proprietors in the colony territory. Now, get back to Professor Abdullah said, when you go into court and appear, so I said, well, I don't use that name. I said, I'm Moorish. No, listen to me. You what you do is you expatriate yourself out of your country for the text of your country. First of all, when you appear first of all, you're supposed to appear to them because you're not a resident or a citizen. You're a non-immigrant. You're not immigrant. You don't have immigration status. You're a non-resident national. You're alien. So an alien don't appear before a foreign tribunal. The consul steps in and takes charge on a consular jurisdiction. When a consul appears, give notice to the central government of the state of the international affairs office of the State Department. What happens is he get council notice, automatically council jurisdiction is created based on a treaty. The only one that's a judicial officer is the council. Once the council rules on that matter, it becomes final. They can't appeal to the federal courts, nobody. The only appeal is given to the council. The council or the government of that nation, of the alien nation. Now, so when a Moor goes inside a court, whether he's using my Moorish name, you give the court's power to speak. You expatriate yourself out of Morocco. You waiving your right as an alien, and you come in now as a what? You come in as, your mama said you come in as a citizen resident. I'm not a citizen of the United States. Well, why are you in their courts? Who defending you? So you defending yourself. So you're not under the text of the treaty. You waive your right of the treaty. You wouldn't say, hey, listen, I'm gonna speak. Once you have to judge a question, you give the judge power to speak. You give the judge jurisdiction over your body. Because now he's able to speak because you grant him that right. You grant him the right to what? Expatriation. You expatriate yourself out of your country by saying what? You're gonna litigate this. I don't care what the treaty say, I'm gonna do it myself. That's not what the treaty said. A treaty don't say that. So you go against the treaty making power.
Let me
treaty
say
of
this.
law land. It's not the courts, it's you. You
Let
have
me
to
say this,
participate
Jim.
yourself.
No, they don't say that. They don't say what you're saying. They don't say, I don't care what the treaty say. They don't. All right.
Now, I know you don't say that, but by
No, hear me out,
doing
hear me
that,
out. Let me, Shim, please. Let me just speak, please.
yes.
Conscious Moors have not been instructed to say that. I got 28 and a half years. They have not been instructed to say the treaty doesn't say that. They've been instructed to say Constitution. Enforce the Constitution. Enforce the Constitution. They've been instructed to use United States Supreme Court cases based on United States constitutional provision, i.e. right to travel, all right? Judicial notice, right to travel, United States Supreme Court cases based on United States constitutional provision. Hauenstein, what is the difference, Abdullah? Hauenstein versus Lynham is a United States Supreme Court case. Yes, it is. Ware versus Hilton is a United States Supreme Court case. Society versus New Haven is a United States Supreme Court case. What's the difference? Those Supreme Court cases are adjudicated based on treaties. And the judicial notices, right to travel, judicial notices are based on United States constitutional provisions and not on treaties. So Moors have been instructed to enforce the United States Constitution, using Article the 4th. They'll say you get stopped. This has been instructed. I was instructed to do this. You stopped. Probable cause. So you're invoking United States. Probable cause. Can I see bring your supervisor? They've been instructed for over 30 years. This is over 30 years of instruction and teaching. I bear witness. I bear witness. Over 30 years before I got involved, 20 of us went to court with Simba. In December 1993, they still doing the same thing today. December 1993 to today, they're doing the same thing today. No progress, zero. Same thing today. They'll call, I got caught today, and they get, try to round up, like with Simba, December 2019, December 1993, 20 of us wearing turban and fezzes, 20 of us wearing turban and fezzes, going into traffic court with Brother Simba. They're doing the same thing today. They call, I got traffic court today. I need people to come with me. So they, same thing. We have to move from that. How do we move from that? This is why education. That's why we had classes on Academy of Pride. This is why we had law classes. That's why I continue to teach. Come to my post on Crumb TV, this class, and continue. They've been instructed to do that. Misconceptions upon misconceptions upon misconceptions. So we have to elevate people to understand the importance of enforcing Moorish treaties through Moorish government structure. Brother Massa and Alamer, who I guessed on Moroccan Post, on Crumb TV, really brought it home. They were in harmony with us.
Yes.
In harmony. And Brother Mansa made a point, very good point, and this is where he was I heard Shem Malachi Bey. When Massa talked, I heard Shem Malachi Bey. When I asked Shem a series of questions in 2019 in Dunkin' Donuts, Shem, I explained to him the procedures that Moore's going to court. What are we going to do different? What are we going to do different? What are we going to do different? It was always, what are we going to do different? If I was hearing the same thing, I would have stepped off him. I ain't going to do this. I mean, what are we going to do different? That stuff's not working. What are we going to do different? I was hearing Shem Malachi Bey when I heard Massa. And he mentioned, Brother Massa mentioned, as Shem has mentioned, that we have to do Moorish government structure, enforce treaties through the diplomatic channels to have a uniform. There is already in place. The uniform procedure is already in place. It's our coming to understand. This is why we're doing this for the next 4 weeks. It's already in place. It's learning it. It's there.
Abdullah,
Yes.
Darian Tucker. I've been trying to access the United Republic of Morocco website to access those steps of
You talk about
facilitating.
politics formation. I'll send that out to you. That's good. Moore's Main Street Part 2.
Okay.
I got you.
I put my
But
email.
I called you. You got it because I called you a couple of times last week, and did you get my calls? Did you get my text messages? Did you get the links I sent? Text you.
Oh no, that was Kawasi's phone number. I guess he was retrieving that for me, but I'm gonna put
I had your number. You gave me. I had two numbers. I had a number you gave me, and a number that Kawasi gave me.
Okay. I'm gonna have to check my messages.
I don't know. So if you want to, the number, I might have written down the wrong number. I don't know. Just text me right now. To see if you text me your number right now.
Okay,
Just
I'm putting in chat.
Yeah, but I want you to text me to make sure that you have my number.
Okay. All right.
Yeah.
Okay. We do have a question on the floor, Handle, for MSTA 4 Indianapolis.
Yeah, is that Grand Sheik Tenon?
No, this is Brother Kadeem Abdullah Bey.
All right, but you with Tenon. You with Tenon Bey? Grand Sheik Tenon Bey. I see a picture. I see his picture. See, I know.
Yeah.
I know.
Yeah. No, that's Temple number 10. I'm with Temple 4.
All right. You're not with Grand Sheik. All right. Go ahead.
Basically, I'm just trying to see if I'm understanding the order. So we go in the form of having a body politic.
Well, we're going to continue with that, brother. We will continue.
No. This is a question pertaining to how you present yourself in court, or more so, I'm trying to give clarity, making sure that I'm understanding that you're saying that we let our documents precede us, a body representing in the form of a body politic, challenging jurisdiction, and also using treaties and constitutional enforcement that pertains to treaties when we present ourselves to have that protection, but we don't appear.
All right, let me address that. All right, this is why I want you. All right, Shem, all right, tell you what, brother, let's hold that. We're gonna hold that for a minute.
Let me address that right now with my mind.
Shem, hold on. Because they don't know what's coming. That's I do, because I put it together. So I know what's coming. They don't know they don't know that all that is coming in this presentation of the next 4 weeks. They don't know that. All right.
Okay.
Because all they can see is one page at a time. They can't see the 28 pages. All right. So they don't know that. All right. That where we're going with this. All right. Where we're going with this, because we can And I love Shem Malachi Bey, man. He sent me about 70 links, man. Where we're going with this is dealing with it through diplomatic channels. We've been taught. I know where Shem going. I know where you're going, brother. I know where you're going with this, brother.
Right.
We've been taught to go to court and not deal with it with through diplomatic channels. Dealing with the looking at the that there are legislation that United States legislates the enforcement of treaties. And this is what you're going to be learning, where that we're using diplomatic channels that we've been on, that all we've been taught are the courts. That's all we know. That's all we know. That's why I say, hold that. We got you. All we know is courts. We don't know the justice, the Office of International Affairs. We don't know that. We don't know Office of International Affairs in the Justice Department. We don't know diplomacy in diplomatic channels. All we know is going to court. That's all we know. All we know is the only way to handle it is go to court, and that's not so. Is that because we, as Master said on Moroccan Post on Come TV on Sunday, because we have not set up Moorish government structure on a national scale, whereby we can deal with this through diplomatic channels. We're learning to do this. And that there are agents, departments, and agencies where we can use through diplomatic channels to address matters. All we know is court. All we know is what the brother said. All we know is what the brother presented about 5 minutes ago. That's all we know. That's all we know. That's all we know. We don't know diplomacy and diplomatic channel. We don't know that. You're here to learn that. You're here to learn that. Shem Malachi Bey has made it a concerted effort in putting this together and putting in heavy emphasis on it. All right, so hold that, brother. We got you.
Islam, gratitude.
All right, continue, Amanda. Because I know what's coming. I already know the whole order. I know the structure because I put it together. All right. All right, go ahead, Amanda. Continue.
Hold on, let me get it back up there. There you go.
It must always be borne in mind that the Constitution, laws, and treaties of the United States are as much a part of the law of every state as its own local laws and constitution. This is a fundamental principle in our system of complex national polity. See also Shanks versus DuPont, 3 Petitioner 242, Foster and Elam versus Nielsen, 2 id 253. The Cherokee Tobacco, 11 Wall 616, Mr. Pinky's speech, 3 Elliott's Constitutional Debates, 231. The People and Company versus Girk and Clark, 5 California 381. We have no doubt that this treaty is within the treaty-making power conferred by the Constitution, and it is our duty to give it full effect. We forbear to pursue the topic further. In the able argument before us, it was insisted upon one side and not denied on the other that if the treaty applies, its efficacy must necessarily be complete. The only point of contention that was one of construction. There are doubtless limitations of this power, as there are of all others arising under such instruments, but this is not the proper occasion to consider the subject. It is not the habit of this court in dealing with constitutional questions to go beyond the limits of what is required by the exigencies of the case in hand. What we have said is sufficient for purposes of this opinion. United States legislation to enforce treaties.
All right, there we go. Here we go. Uh-oh. Uh-oh. Here we go. Here we go.
United States Senate
I want you
Committee.
to read that and then Shimba take over.
United States legislation to enforce treaties. United States Senate Committee on Foreign Relations is a standing committee of the United States Senate charged with leading foreign policy legislation and debate in the Senate. United States Committee on Foreign Relations to the United Nations, January 20th through the 21st, 2000, address before the UN Security Council by Senator Jesse Helms, Chairman, field hearing, implementation of UN reforms, review of United States participation in the United Nations, hearing before a subcommittee of the Committee on Foreign Relations, United States Senate, 88th Congress, first session, March 13th, 1963. The 13th report, U.S. Advisory Commission on International Educational and Cultural Affairs, June 30th, 1977. Excerpt from U.S. finally ratifies Human Rights Covenant by former United States President Jimmy Carter. This article originally appeared in the Christian Science Monitor, Boston, Massachusetts, June 29th, 1992. International Covenant on Civil and Political Rights, the ICCPR. In 1966, the ICCPR was adopted by the United Nations, but no action was taken by this country until October 1977, at which time I signed the covenant and submitted it to the Senate for advice and consent as required by our Constitution. The Senate gave this consent in April 1992, and in early June, George Bush signed the instrument of ratification. On June 8th, 1992, the US, one of the key players in drafting the covenant, finally ratified this important human rights treaty. Ratification of the ICCPR provides an excellent opportunity for the US to strengthen civil liberty provisions in domestic legal codes and affirm that international standards such as treaties prevail as the law of the land. Ratification also induces our government to examine more closely the reasons for the upheaval that has shaken the US in the wake of the Rodney King verdict.
Yeah, that's just an excerpt of the article given by former President Jimmy Carter in 1993. All right.
Codes of Federal Regulations.
Hold on, before you go there, Shem, you want to comment? Your phone.
You're on mute, Shem.
Yes, United States became a full player. First of all, when the United States endorsed the Charter of the United Nations, that became a World Congress. Now, when the United States endorsed that charter, that became legally binding as a treaty against the states. So now, the United States got to play ball now as a member of that foreign corporation, the United Nations, the Foreign Society of Nations. And remember now, all these nations that formed that, they ratified a charter of nations that signed treaties with Morocco, Great Britain, Spain, France, Denmark, Dutch, Sweden. These are all nations that signed treaties with Morocco. So United States know that there's a stake involved here when they ratify that Constitution. So now what happens is the Senate made a decision to create a subcommittee of senators so they can give their opinion on international law and the resolutions that passed the UN. So they created the CFR. It's called a Committee of Foreign Relations. Now what happens is, I put together the ties to the Council of Foreign Relations. But that subcommittee is the one to create all the federal statute codes, everything, and regulations. So deal with international law here. This is the meat right here in the pot. This is the meat of it right here. The Senate has created a committee of senators to make sure that the of the United States is follow out on all the international treaties, acts, and conventions signed by the United States. And it's very important. So the Moors, conscious or unconscious, know that the nations follow international law. The only problem is we're not arrayed and government arrayed. We're not following because we were unconscious for a while. We have to get back to political structure and our government arrayed and enforce these treaties and the international acts. And let me explain something to you. Why form a government is so important? First of all, number one, when you form government, the government can designate a council or a deputy. They become what you call a judicial officer under a treaty, judicial officer that have all the ruler-making power. They have their own jurisdiction. The United States got set up in the Justice Department, an organization that will hear all foreign matters of foreign nations as a treaty of the United States. They step in an intervention and supersede, and the federal courts have no jurisdiction. What's decided by the council cannot be appealed to the United States Supreme Court. That means the council has exclusive jurisdiction and rulemaking power. It can't be appealed. The only way it can be appealed based on what the treaties say and what the subcommittees say based on the contracts and conventions. This is very important that we know this.
This is why I was saying to you, brother, that hold on to your fares, because this is a different angle and in line with international law and treaties, Moorish treaties. So, like I said, you immediately went to what you've been instructed. I know that. I know that, so that's all you know. That's all a lot of conscious Moors know. All right? Because it's been out there for so long. I mean, so long. It gained a lot of, you got tentacles. You got tentacles, a lot of tentacles that's pushing that. And it's been, and it gained root. And that's, all right? So this is going to gain root. This is going to gain root. And I said this to him in front of his mother's house, right outside where he is right now, back in April 2019, that we can gain root with this. It's just going to take time. I know he was fired up and he was ready to go. He was ready to go 10 years ago. He was ready to go 10 years ago. So, you know what I mean? So I had to slow him down, boy. I had to slow him down. All right? But I love the brother. He's bringing it. All right. Any questions?
Yeah, I got a
No
question.
questions?
Yep, nope,
Yes, go ahead.
All right. Islam family. Do the treaties have any expiration? Do any of the treaties have an expiration date?
El-Kanan asked Master that question on Sunday. So this is not El-Kanan's first. He asked me, last week. He asked Brother Massa on the Moroccan Post on Crumb TV, which is great. And he's asking Shir Malachi Bey tonight. Yes.
Okay, let me say something. First of all, the power to put a time frame on the treaty is upon a hosting nation, not the foreign nation asking a mission to be there as an ally. It's put upon a hosting nation that's allowing the other sovereign to come in to run a government and have a private society, a private community. So when a treaty don't have an expiration date, that means the ruling power of Morocco did not put an expiration date on that treaty. That means that treaty will stay in force until the hosting nation go before the World Court and file a notice of termination of all rights of that nation in their land. Remember, we're not in the United States. It wasn't formed. We're not in the British Dominion, in England. We're not in Spain. We're not in France. We're in Morocco. So therefore, we're the hosting nation. When something like that happens, the council for that nation get notification to that nation to terminate all obligations under that peace treaty. That means that now because there's no date in there, that means a hosting nation did not put a stipulated time for that nation to be in their land. So look at it this way. Somebody said, well, somebody look and say, well, the treaty don't have expiration date. That's good. That's good for the foreign nation. I mean, we can't tell them to get off our land until we got a government and go before the World Court and say, we want to terminate that treaty, rights that we gave them back here 200 years ago. If the ruling power, the hosting nation, I'm talking about, listen, Ferry, the hosting nation is the one that got power to determine the treaty, how long that nation stay there, how long peace stay with the nation in their land. If the hosting nation don't put a time period on there, then that means that it's a definite until the other nation file a termination of that treaty. That's Morocco. So they can't file a termination of that treaty. If they do, they can no longer be here doing their business in Morocco. So they can't terminate the treaty. They need the treaty rights to be here. Without a treaty, they can't be here. Because Great Britain can't be here, France, Spain, Denmark, Portugal, Dutch, if they can't be here, the United States corporation will fail. The nation, the colonies can't have a charter here any longer because the treaty to terminate are all European powers. So because a treaty with the United States or treaty with any European power don't have an expiration date, that don't mean the treaty not enforced. That means the ruling power of Morocco did not get expiration date for them to stay here. So that's benefit us and them too. Because they can say, well, there's no termination of the treaty. We can stay. We will do business in Morocco. So because a termination date is given by the hosting nation, who's the sovereign of the land, that's Morocco. You understand?
Let me say this. We are analyzing. Our questions are born out of our observation. That's all it can be. That's all it can be. And your observation is that you don't see a national Moorish government structure. None of y'all do. I don't, Shim doesn't, no one. All right. You don't see a national Moorish government structure. All right. So you see what you do see is a body of Moors fighting each other. You know, that's what you see. You see body of Moors fighting each other and trying to pull rank and whatever. That's what y'all see. Y'all see, you know, this organization in some areas. All right. Now I want y'all to envision. Just envision. Close your eyes and imagine. Close your eyes and imagine a world with the restoration of Moorish government. Close your eyes. I know it's kind of hard for y'all to envision that. All right. Because I think y'all will come with different questions because you only come with questions because you don't see it or you can't envision it. I can envision it. All right. And everybody can't, everybody's not me. Everybody's not me. So they only can see what they see right now. I mean, they can only see what they see right now, but I can envision it. All right. So I don't expect everybody to envision it. All right. So this is a preparatory stage. You know, as I continue to reach out to all my contacts, all my Moorish contacts I've known. All right. As we can continue to build this, facilitate Shem Malachi's base plan is a facilitation of a Moorish inter-government alliance, a Moorish inter-alliance of various Moorish body politics as a step to, as I mentioned on yesterday, which it was recorded yesterday. I was with DJ. DJ recorded me for an hour and 10 minutes, and he'll give that to me, and I'll send that out. And we were talking about my upcoming book, Moors and Masonry Part 2. And I explained to him the procedure, the process of Shem Malachi based plan. What does that mean? And I came with international law, political philosophy, and political science. I combined all that knowledge that I have of that, there are 3 subjects, into analyzing Shem Madagai Bay's plan. The facilitation of a Moorish government alliance with 25, 30, 40, 50 Moorish body politics where heads will be represented, the heads will be sent up, all right, to form this Moorish intergovernment alliance. And from there, form a Moorish Imperial Parliamental Council to draft a temporary, it cannot be permanent. Let me explain. You must understand political science. It must be provisional, which means a provisional means temporary. Because we must facilitate a plebiscite among millions of us, a plebiscite. But we can facilitate a Moorish provisional government. And that will be written out as a provisional government, stipulations and time period, a year or 2 years, whereby we can address the matters of mass denationalization, genocide, colonialism, intercaterra divina on the international scale. And we would have a time period of this Moorish provisional government and being in line with political science and political legitimacy to facilitate a plebiscite, which means a national vote. I mean that, and in this provisional government, there will be a structure to continue a large community outreach and education of nationality among the millions of our people, with funding coming, funding and dealing with the active Algiers. This would all be written out. We don't need all our people to be conscious. You structure a provisional government and as a road to a permanent government. It's understanding political science, political philosophy, and international law. We can do this, y'all. This is not above us.
I want to make a comment real quick. I want to help facilitate that. There's about probably the islands, Africa, those of us who are represented in Europe. I want to go ahead and set that up. I'm tired of bullshitting. I mean, I'm done.
That's what I want to hear. Say one more again.
I'm tired of bullshitting.
Say one more again.
I'm tired of bullshitting. That's it. I'm tired of bullshitting. Because see, the thing behind it is, and I don't want to hold the mantle as if, you know, I'm somebody or whatever the case it is, but the fact of the matter is,
you are somebody. No. You are somebody. You are somebody. You are somebody.
All right. I mean, I understand that, Abdullah, but I'm saying I have a large reach. And for years, you've been trying to get me to get the fire up underneath my ass. And I've just been sitting there just like, man, but I'm not going to make the statements that I was making before. I can help facilitate that. Me, you, Shem, Mikael, a few of us can go ahead and we need to just start having some meetings ourselves and then start putting the larger communities together, because I know how to set up the international bodies, the contracts, the supreme body that will be the overseeing body of all of the individual grand bodies that are in each of the different states, and then the municipalities within those states, so that there is a hierarchy or there is a duty of each one of those municipalities in each city that report to the actual state. That state has a representative. That representative becomes a part of the actual supreme body and that supreme body meets, and they will be taking in the needs of all of those city or municipalities within that particular state. So I can set that up. I have the documentation for it, I have the paperwork for it, and the whole 9 yards. I'm ready to go down, have this meeting. We can do it on Zoom. We don't necessarily need to fly all over the world or whatever the case it is. I'm ready for it, and I yield the floor.
That's beautiful, because I put together a constitutional monarchy of the people, and how it goes is that all the states of provincial governments will ratify that I got a stats called Moroccan International Association. Moroccan International Association of States of Morocco. All of the associated states of Morocco. Now we become the same power the Sultan have. We'll have it as a republic. All these provincial governments will operate as one, as a government. Inside that constitution, I've got the trustees. The trustees are the societies, the congregations, and the communities of the Moorish states that got power. They're the trustees. Why are they trustees? See, we got to give our people power. Why are they trustees? Anytime a political corruption within the government structure, the trustee can step in and change everything. Have a committee set up. This one is written so genuine. Professor Abdullah gonna look it over. He gonna always see it, look it over. I'm gonna give it to him. He gonna review and look it over and tab it up, and then he lets you know when it's ready. So what happened is anybody will become a provincial government. If you don't have a constitution, all you gotta do is create a structure, see a representative up and ratify this international constitution and act as the power to be a state in Morocco. See, I'm setting everything up to our consul, our states. We can do our own clemency, our own name change, all that kind of stuff. We got the power to do all this stuff. We get a government structure to help our Moors govern people out.
Well, I wasn't expecting. Well, I was, because I do have this written out later on, but
I mean, no, I'm not jumping the gun. I'm not, because Shem said it's provisionary. You know what I'm saying? And if it's provisionary, then we can just go ahead and we can just set it up. There are already particular groups that are there, or whatever the case it is. I know everybody's gonna want to have, a little position here and there, whatever the case it is. And I'm not being funny about that, and that's fine. But of the groups in each of the particular municipalities in those cities can go ahead and they can figure out who their structure is. We can set it up like a divan, set it up, have those particular individuals that are in place in that particular city. And then each group that is represented, there are 12 members in the divan, each group that is represented can come underneath each one of those representatives for that city. The one person that's over that particular city, then those people would come together as a group, and then they themselves would elect a person who's a delegate for their state. Then from that point, those states come together, and once those states come together,
you got it, brother. You got it. You got it.
I've been involved in this structure. I've been involved in this structure for 33 years, 33 to 35 years. So I know how this structure is set up, whether it be nationally or overseas, and I have the actual contacts of the Filipinos, the Venezuelans, those Moors who are classified as Filipinos, Venezuelans, Mexicans, all of those different things. So you know what? It's time to do it, and I'm gonna start the conversation tomorrow. So Shem, Abdullah, Mikael, we'll start with the governing body, and then we'll go ahead and then start reaching out. It's a matter of us start reaching out to those individuals. So we're gonna get this started tomorrow. So Shem, I expect to be in conversation with you. Abdullah, I expect to be in conversation with you tomorrow as well. Mikael, I don't know if he's on the line right now, but we're about to get started with this.
Is Mike on?
Today.
Is Mike on?
Peace, I'm here.
All right, go ahead,
All right,
Mike.
Mikael, Islam.
Peace and love, brother. Peace and love.
Peace and love. So anyways, I yield the
Brother
floor, but
Akeem
I
is
will
doing
talk to
some
you guys
wonders.
tomorrow. I'm gonna stay on the line, but we gonna have this conversation tomorrow, and we gonna keep doing what we doing. We keep building. We're building the
Yes, my
consciousness.
Moorish
We're gonna
brother.
keep
Yes,
on
my
doing
Moorish
it.
brother. I love you. Yes. Yes, my Moorish brother. Africans are Moors. They're my Moorish brothers. They've been under conquest like we here in Morocco have been under conquest. The only thing we gotta do now is stop dividing ourselves. I don't care what part of the world you're in. If you got carbon and melanin in your skin and visible pigment, you're a Moor. That's what we gotta understand. We gotta start dividing ourselves. We all Moors. I'm gonna show you. What about the Europeans? They been taking each other. Look at the Europeans fighting Ukraine and Russia. The Albions fighting. Watch it. The Albions over here are not taking no side. They're stepping in. Why? For the protection of the European power. So when they not saying, well, he no Albion. So we gotta stop. We gotta look at them. They're showing us up. I don't give a man for Africa. He's a Moor. That's all it comes down to. He's a Moor.
Well, you know what? Think about it this way. Africa has been not at the Kemet, because that ain't Africa ain't the real name anyway. So we've been conquered anyways. You know what I'm saying? So we all in the same boat, and it's just a matter of us waking up. So,
Yes.
This is where
Well,
we
one
are.
day, brother, you woke, brother. I'm glad you woke. I'm glad you woke.
Yeah,
With that
well,
mind you got, I'm glad you woke. You got a good mind on you.
It was
woke.
a long sleep, man. It was a long sleep. Now it's time to wake up and get about action.
Me Abdul gave the smelling sauce.
That's what it was. That's what it.
Come on, butt kickings. You know what I mean?
And I'm tired of you kicking my butt. Maybe that's what it is.
I love.
Hey, Moore, I'm glad you woke. And listen, I'm glad to have a friend like you or more like you that's woke. You woke. You awakened. You recognize.
Oh, he is.
See,
He's
I'm gonna tell you, you know the key thing of this is Abdullah. One thing I love about Abdullah woke me up to something. When I say we talk about voluntary and voluntary, Abdullah correct me. I said, no, Abdullah is not voluntary because they did it by force, trickery. I don't give trickery and because somebody is a form of device of force to somebody. Intellectually, you take intellectual mind and force somebody to do something. So it's not voluntary, it's involuntary what's going on with us. So what happened if we just, our mind, once we recognize who we are and accept that the inherent power is in us to recognize who we are. The Supreme Court made that clear when they enforced ancient jurisprudence, when the Commonwealth, the Attorney General of the Commonwealth of Virginia say that no tribe can be recognized unless the federal government recognizes them. So the Supreme Court said that is faulty logic. The right of a tribe, of people to recognize themselves as an inherent right. United States, although they call it United States, but they what? They Germans, Irish, Italians, Portuguese, Dutch, Sweden, British, France, Spain, French. They're all of these different nations. And one thing about it, you ask them where they from, they tell you that's our French, our Spanish. Why they say that? They go back to their roots. So we on the other hand, they'll say, well, I'm an Albion, I'm an Albion, I'm white. They'll say that.
No, not like that. No, not
go to the Constitution, right? Go to the Constitution. In the United States Constitution, there's not a political status written in that Constitution for them people. Remember, the Lord Proprietors instructed the Esquires to write the Constitution. There's not a political structure, identity for a United States citizen in that Constitution. Watch this. Not only that, they didn't even patent the flag. They don't have a patent flag. So the flag they use is the British flag. It's a Commonwealth flag. And the seal is not their seal, because they don't have a seal patent in their Constitution. Look at a lot of Constitution. They patent their seal as an emperor. They patent their flag. So what that tell you? They operate as a sovereign on somebody's authority. Read the Constitution. The Constitution got to have a patent on the seal and the emperor of the government and the flag. It got to be patented inside that Constitution. And the political status of the people got to be set in that Constitution. If you don't have a political status in your Constitution or proper copyright in your flag or your seal as an emperor, that means you operate in somebody else's power. When I look at your flag, you got a design flag But it's not patented. Why? Because you wouldn't allow to patent them colors and the stars. You wouldn't allow. Because they already had a patent on by somebody else. See, all of you come a jurist, you see all this stuff. You overlook all the jurisprudence. I'm glad you're a Moorish brother that's woke, brother. I'm glad. Glad to have you aboard the ship.
I'm glad to be here. Glad to be here. Finally awoke.
All right, this is great. I didn't want to, can we move on or we good?
Yes.
All right, Amanda?
Yes. Okay. Codes of Federal Regulations, 28 CFR, .64-1, central or competent authority under treaties and executive agreements on mutual assistance in criminal matters. Title 28, Judicial Administration, Chapter 1, Department of Justice, Part O, Organization of Department of Justice, Subpart K, Criminal Division, Section 0.641-64-1, central or competent authority under treaties and executive agreements on mutual assistance in criminal matters. The Assistant Attorney General, Criminal Division, in consultation with the Assistant Attorney General for National Security in matters related to the National Security Division's activities, shall have the authority and perform the functions of the quote-unquote central authority or quote-unquote competent authority or like designation under treaties and executive agreements between the United States of America and other countries on mutual assistance in criminal matters that designate the Attorney General or the Department of Justice as such authority. The Assistant Attorney General, Criminal Division, is authorized to redelegate this authority to the Deputy Assistant Attorneys General, Criminal Division, and to the Director, Deputy Directors, and Associate Directors of the Office of International Affairs Criminal Division. International law and agreements, their effect upon U.S. law, Oxford Academic, the legal effects of treaties in domestic legal orders and the role of domestic courts, pages 1 through 60 by Mario Mendez, published March 2013. The basic precept. The core precept of the law of treaties is the principle of pacta sunt servanda, enshrined in Article 26 of the Vienna Convention on the Law of Treaties, and which states that, quote, every treaty in force is binding upon the parties to it and must be performed by them in good faith. But whilst treaties are to be performed in good faith, it remains that the case that they are in principle no exception to the basic precept of international law that states are free to determine how they meet their international obligations. It is indeed rather striking that treaties do not, as a general rule, impose specific requirements as to how substantive obligations that they lay out should be realized in the domestic legal orders of the contracting parties. There are several interlinked factors that have been adduced for this seemingly curious state of affairs. The core issue relates to the traditionally central tenet of international law, that of state sovereignty. As one scholar put it, states consider that the translation of international commands into domestic legal standards is part and parcel of their sovereignty and are unwilling to surrender it to international control. Accordingly, states in principle are said to be concerned with whether compliance with the treaty obligations takes place and not with how this does or does not come about. Related to this is the fact that states have developed different approaches to seeking to ensure compliance with their treaty obligations, which renders it all the less likely that treaties will expressly address themselves to how the obligations should be given effect internally. In short, international law leaves it to the domestic legal order to determine how it gives effects to its treaty obligations in the domestic legal arena. In this respect, a recent detailed assessment concluded that there is no general obligation under general international treaty law, customary international law, or general principles of international law, requiring states to open their courts for invocation of treaty norms by individuals. It is clear that, however effect is to be given domestically to treaty obligations, a state cannot invoke its international law as justification for failure to perform. There are, however, exceptions to the basic rule in that the case of some treaties, states have sought to constrain this freedom of maneuver by stipulating some requirements as to how treaties or specific provisions are to be given effect in the domestic legal order. Thus, for example, treaties and specific treaty provisions can be drafted expressly to require the contracting parties to enact internal implementing legislation. An example of a treaty containing an express requirement for legislation to give effect to its provisions is the Genocide Convention of 1948, Article 5, the Geneva Conventions 1949, for their part, constitutes examples of treaties containing specific provisions calling for implementing legislation. And indeed, in the general sphere of international criminal law, it is evident that treaties have become increasingly exigent. In the UN Convention Against Torture of 1984, for example, contains a provision requiring each party to take effective legislative, administrative, judicial, or other measures to prevent acts of torture in any territory under its jurisdiction, as well as a provision requiring the criminalization of certain acts. Judicial enforcement of treaties, self-execution, and related doctrines.
Just a minute, a moment, though, Amanda. Shem, I want you to speak. This is good review here. To the implementation, further speak to the implementation legislation of treaties and the Committee of Foreign Relations, the Senate Commission of Senate Committee on Foreign Relations, right? And the implementation legislation of treaties. All right, this is a great article here. All right, and I want you to speak to that because we need to continue to hound this point, all right, and understand Moorish the importance of government structure, and in order for us to force treaties through the diplomatic channels, is to go through the diplomatic channels as a governing as those who be a Moorish consul going through diplomatic channels, all right, to address treaty violations, all right.
Yes.
Understanding the implementation of legislation, that there are agencies already set up and legislation on how the United States is to implement their treaty obligations. All right, so I want you to address that.
Yes. The United States ratified the UN Charter, and the president signed it. The United States had an international commitment to a foreign government body. Now, once that happened, resolutions that signed and passed by the representative, by the resolution that's passed by representatives of the sovereign nations. Now, remember, United States, whatever France signed and Great Britain signed and Spain signed, Portuguese, that's binding against the United States. So the United States want to have a full say in the resolution legislation that's drafted by the UN through what? The resolutions. So the United States selected senators and created what's called the Commission of Foreign Relations, called a committee. It's a committee, a foreign committee, the Senate Foreign Committee. What the Senate did was, when they go ratify something, they would sit there, Senate Representative Ambassador, to become part of the rule-making power of the UN. And then when they sign a convention, a declaration, or treaty, they come back and pass what you call legislation, which is called codes, bills, statutes, and rules. The government within the United States jurisdiction, territory jurisdiction, Georgia, Pennsylvania, all of them in the territory and jurisdiction of the United States. Why? Because all that territory are colonies. Once the United States is granted the right to go back into the colonies, they're given the rights over all the extended territory that the Crown had already. acquired from the indigenous people. So now the United States sits as the parent, I'm about to say the trustee for the crown, Spain, France, Portuguese. What happens is now they create what you call international organizations that deal with the international body, international law. Like for instance, they got in the Justice Department, State Department, because Justice Department is part of the State Department. Inside the State Department, Office of Foreign Affairs, there's a central agency that was delegated by Congress, appointed by Congress, to hear all foreign matters dealing with any kind of international convention, treaty, declaration signed by the United States, ratified by Congress, signed by the president. Now, that organization got power, the oversight, as if the federal courts have power to hear diversity citizen status between the states. The agency got power to hear any foreign dispute by a foreign nation treaty the United States or United States signature to any international agreement or incident. Their job is to create a jurisdiction where the council have power to hear the case internationally. When the council hear the case, that agency assists the council in a letter of obligatory to take evidence, bring witnesses, but the only one that can rule in that case is the council. And the council rule based on what? Let me explain what I mean.
Somebody put their phone on mute. Just put the phone on mute.
The council
or something,
is the one to make a final determination. Now, once the council make a final determination, no United States agency or state can go to the federal court and challenge that on the federal question because the council got jurisdiction. I sent out a duplicate case where the United States Supreme Court say that anything dealing with, let's say for instance, the Department of Immigration, if an officer of immigration make a decision on immigration status, and Congress provided that the immigration officer had the final say, and that's plain language, you can't appeal that immigration officer decision in the United States based on that statute or that federal bill or act that passed by Congress. So when you run a government, diplomacy means that the council, for instance, I'm giving you, when they wrote the Constitution, every say a man right to have right to counsel. So now the United States wrote that in the council, a council. Now, under British common law, they didn't have a right to counsel. But they wrote that in so they have a representative to represent them from their government, from their foreign government. Any dispute within the colony territory among themselves. Under international law, a foreign nation, two foreign nations come together and make it and give a council, which is an international officer of power to hear disputes between the two nations. Nobody else can intervene. So what Congress did was they designated an organization inside the Justice Department that had the only legal rights to hear a dispute, civil or criminal, between two foreign nations in a treaty. I mean, the United States in the treaty, the agency, the only one, had power to hear that case. In other words, the council had to do a notice to the agency for council jurisdiction, give the council exclusive jurisdiction over the whole matter. Therefore, a letter of obligatory submitted to them. That's called diplomatic relationship, government-to-government relationship. Knowing the federal courts does not delegate Congress and the treaties and national law do not delegate authority to a state. That power to delegate something to a foreign national, which is an alien, non-bound, a non-citizen resident, a non-immigrated status. That's an alien, a legal alien. And once that happens, there's nobody else in the world but what that organization in that council decide. The council make a decision. Once you make a decision, it can't be appealed in any court of the United States. And the reason why the subcommittee selected senators, the senators came together and selected senators among themselves, create a committee, because they want to be the ones to pass the bills, statutes, and regulations on these laws being enforced. So they will go in default. So the United States is going default too. And this is what default means. When you sign a contract, that's an obligation, liability against you. When Congress signed that charter and ratified that charter, and the president signed it, it became an international liability obligation against the federal government and the states. And if they don't do it, they can go to foreclosure. This turn United States going to foreclosure. How it done? United States banking system is determined by what? France, Spain, and England. If they shut down their currency system by banking and doing commerce, and that's called sanctions. That means they can't export their goods. If they buy goods, somebody buy it for $20, they may have to spend $200 for that goods. That's why the price of oil was so high and gas. Why? Because they won't tell you this embargo, sanctions. When you don't go by international law, all these nations that control the export, import, oil, gas, cinnamon, agriculture, when you go to buy, you're not producing. You go to buy, you go to default. I mean, you default what? A contract, a treaty, an obligation. Therefore, you sanction. You go to foreclosure. What's foreclosure? That means you don't have power now to sell or use the currency system. That's why the dollar go up, got no value. That's why the United States have to be obedient to international law. Because if they're going to foreclose. I'm teaching y'all something they ain't going to teach y'all in college, school. Please listen to me. When you deal with contract law, you have to deal with an obligee, a guarantor, and a principal. Who's the guarantor? United States citizens. The territory. Why? The obligee is the crown. Spain, Great Britain, Spain, France. The principal is the nations that sign and ratify the Constitution. So United States is the guarantor. They got an obligation on them. See, I'm trying to break it down in contract law. United States operate on a trust. They operate on a trust. They're a trustee and a settler or the truster has all the rights. That's the creator of that trust, the crown. Was the creator of the colony charters given to the Lord proprietors. United States didn't create none of the boundaries. The export commerce already created. The money system already exists. They came in and started operating government, making the people pay what? Tribute, suretyship to the crown, the Lord proprietors. And they said, so it's very important. Everybody did this?
Jim, you know what the problem is that because of the misconceptions, I mean, because the questions are asked based on people because of the misconceptions been out there for over 30 years. You know, the misconceptions, the misperceptions of the procedure. This is new to a lot of us. This is new. All right. This emphasis of a treaty enforcement on how to do it, diplomatic channels. This is new. All people been hearing, enforce the Constitution, enforce the Constitution, enforce the Constitution. I mean, they've heard that over 1,000 times. You know, let me call my boys up to go to court with me, traffic court with me. That's all they know. All right, so we have a question. Who's hand? I mean, we have Hakeem, your hand is up.
Yeah, peace and love, brother. Peace and love, brother Shem. I was just wanted to chime in for clarity purposes. If Brother Shem can explain and elaborate on the difference between a council, which is COUNSEL, and a consul, which is CONSUL. If you could just for the audience just explain the difference between the two, because there might be some confusion between the difference between a counsel, like a counselor at law, an attorney, and a consul, which is a government official. You just explain the difference between them.
A counsel is an assistant. That means under college charters, they didn't have nobody a lawyer, somebody that's assistant that's trained in law, jurist. That's why they put in the Constitution to write the counsel. Now, right, the consul is the international term for an officer delegated authority by the government to hear foreign matters and foreign affairs, dealing with that nation in a contract or agreement with another nation. So I'm gonna give you an instance. Let's say a mortgage stopped. He's in government structure. He got an ID every day set up. Right? If the law enforcement officer have a dispute, he don't say, I want to see a supervisor, or he say, well, I don't answer questions. You got to call the council office. He gives the central authority, the Justice Department. When you say that, everything shuts down. Why? The moment he called the council called the central office, the organization steps in and said, wait a minute, he's a national, an alien protected by treaty. Under federal law, he's protected. Now, the law enforcement officer, the governor, everybody that state administrator, city council, don't have no jurisdiction over him at all. The council got all jurisdiction over him.
Hey, Sean, let me say this though. We're gonna have to prevent that stat. Hear me out, please. We're gonna have to prevent that. Mansa, Brother Mansa, on Moroccan Post on Crumb TV, made a very good point of in setting government structure up and addressing matter and facilitating through the diplomatic channels, whereby we will prevent that from happening. What I'm saying is, let's prevent the stop. All right. What I'm saying is, we continue to go with the stop. We get, because that's what we are right now. I get it. We go with the stop when a morgue gets stopped. Shim, I want you to talk to what needs to be done to prevent the stop. Where it doesn't happen at all. Prevent the stop. Let's talk prevent the stop. Let's talk that. We gotta talk prevent the stop.
Yeah, when you got a Moorish government set up and they vested with the international body, automatically when the council is the one to go before Homeland Security, the Department of Homeland Security, and the Department of the United States Congress have placed that agency over all the government administrative agency, Homeland Security. What happened is Homeland Security have informed that the council fill out for the national and send on all his identification and paperwork and certificate he got from that government, and they give him what you call a number, a certain number and everything, and certain documents to go with his passport and his ID, a passport and his ID as an alien protected by treaty. When you driving, your government, first of all, your vehicle, all vehicles must be transferred out of the state into that Moorish government state. And once they have it, the Moorish government give you what you call a certificate of origin. And registration in that vehicle now has left the state jurisdiction, become under the text of the foreign nation under treaty. Now become property, trust property of the government. Now under Foreign Asset Control Act, the government cannot take from another government under treaty their property. So when that happens, if the officer, remember, a lot of them only do this because they're not trained. So you have to contact the council. The council steps in and say, well, he got the proper paperwork. You don't argue with them, but I'm not saying you're not going to stop. You got some police officers out here, a lot of them, they're not trained. They're not trained in national law, I'll be honest. They're not funded to be trained. So they don't know.
Shim, that doesn't stop. What I need, let me, hold on, give me a minute, Shim. That doesn't answer, all right. That doesn't prevent the stop. I'm talking about preventing the stop. All right, let's take it a step further. We're talking about preventing the stop. Now, hear me out. We got to talk about going from Joe Biden down. Joe Biden, a proclamation. We're talking about let's talk preventing the stop. That's preventing the stop. Joe Biden putting out a proclamation to all the government. Let's talk.
I got you evidence that Moorish government, I'm doing right, that Moorish government, once everything is set up, the Moorish government sends out a proclamation to the State Department and the Justice Department, that organization, that the Moors are licensing, are registered on vehicles, and they're issuing on what? On identity, operate these vehicles. Once that proclamation goes from that Moorish government, now that notice going to all law enforcement agencies of the state that you see these vehicles, they're not to be stopped and detained. That's government-to-government relationship. Now, I'm not saying that if the proclamation go out and say that these are the tags, this show a copy of your sign, which is your tags, and the paperwork the national will have, ID, identification card, ID card, operation service card. Now, once that go out, that's called government to government. That's coming from one government to another government with a proclamation. It's a public notice. When that notice go out, all the states and the county, the municipalities get that notice. Here's the thing about it. Once they go out, they have to be trained. They have to be retrained now on international law. That it's aliens traveling with possession rights. So that only be done to government. A proclamation coming from the government, and not only the council. The council, if you have to visit the attorney general in each state. Hello? Can you hear me?
All right. All right, so we're talking about, once again, we're talking about preventing the stop. All right, so Shim, let me slow you down for a minute. Let me slow you down. All right, Shim mentioned training. Shim mentioned training. Once again, we talk about a proclamation coming from Joe Biden. Joe Biden to all the governors. And the police department go through training. It's with, all right, money is legislated by Congress, United States Congress. Put your phone on mute, please. Phone on mute, please.
That's Shim's background. Everybody has their
all right,
phone on mute.
Yes, all right. We got to talk preventing the stop. We got to get there. We got to get preventing the stop. It's almost 30 years I've been hearing when you stop. When you stop. I just don't want to hear that anymore. I don't want to hear that when you stop, this is what you do. We're on the level of talking preventing the stop. By setting government structure up, preventing the stop. Joe Biden sends out proclamation. Congress legislates funding to train the cops on who Moors are. Just like your job, those who have jobs, they get what's called sensitivity training. That's mandated, like they had the Chinese, like in that issue, where you had to get your job and you had to take a test. You had to watch a video. So they will watch a video on who the Moors are. You know what I mean? It's like they watch the video, the Chinese, and sensitivity training about the Chinese. They watch a video on who the Moors are. All right? They go through this training. We got to get there. We got to at least talk about it. I mean, we got to get there because it's when you stop. I want to get past that. I want to get past the when you stop. If we never talk about how to prevent the stop, then we'll never get to how to prevent the stop. As long as we stay in when you stop, this is what you do. That's 30 years for me. That's almost 30 years when you stop. That's almost 30 years. I want to get to preventing the stop. I want to get to sensitivity training for all the cops. The cops are taught who Moors are. They taught who Moors are. It ain't no, I don't know who a Moor is. We got to kill that. We got to kill that. I don't know who a Moor is. We got to kill that. It got to come from Joe Biden down. Legislation funding already, sensitivity, educational funding coming from Congress. Educational funding coming from Congress on sensitivity, educational training of who the Moors are. All right, hear me out, please, my brothers and sisters, please. Just like the Justice Department, that report that I've chapter 12 of Moors and Masonry Part 2. Chapter 12 of Moors and Masonry Part 2, that report that was done by this private agency that was under the funding, guidance, and leadership of the Justice Department. All right? That report, the Moorish Nation is a sovereign citizen movement. Moorish Nation, the sovereign citizen movement. That was done under the guidance, funding, and leadership of the Justice Department. Hear me out. I know what I'm talking about. That report was sent to all the police departments. What I'm saying is, Just like that report was sent to all police departments and the captains and sergeants of all these various police departments and municipalities, towns, townships, thousands of them. And they briefed them. They had a meeting. Hey, y'all, they briefing the cops. You know what I mean? Like, how they come in on their shift. They come in on their shift. Y'all seen TV. Y'all coming on the shift. Yeah, so-and-so, some crime, and we looking for this such a person, all right? Just like they did the sovereign Moorish Nation, the sovereign citizen movement, Moorish Nation, a sovereign citizen movement, they were briefed on that. What I'm saying is, just like that, they were briefed on who we are. No different. No different with that same report. We briefed, right? That's what I'm saying. If we don't talk about it, if we don't educate direct to this, it'll never happen. When my brothers and sisters, I'm not talking out of my butt. Look, there's more resources spent on individual cases upon criminal cases. There's more resources doing that. And nowhere further along than you were when you got started. There's more resources with the individual approaches. There will be less effort, less resources with unity. I'm not talking out my butt. I yield.
Question on the floor. Hand raised. MSTA for Indianapolis. I'm sorry.
I have a question, Terrence.
That's fine. Basically, one of the things that I see and something that should be taken advantage of and is more science temples formed that are not incorporated, that go in under the banner of I believe the Emiliel, in those formats where the temples are not under the jurisdiction of the United States by being incorporated, and then Moors getting involved within that body and forming these governments, basically facilitate and provide a place where Moors can meet, because that's between that and Zoom, we could probably reach more people, because it's a known, Moor Science Temple is known, and it's a place, a meeting ground where Moors can come in with like-minded Moors to facilitate the things that we are reaching out to do, because it's hard to really have people be consistent without a proper meeting place, because going to this person's house, going to that person's house, it's not the same as coming to a temple, just like you have a mass coming to a big church. So I think that would help a lot of our situations of reaching the mass at a faster rate when a lot more temples can be established for these type of things.
Let me say this: during the pandemic, during the fraud, during the fraud, people met on Zoom. They met on Zoom. So I mean, because you said something, but I'm saying there was no building. People were not meeting at buildings. People were not meeting at buildings. They still had churches. They still had church sessions. They still had church sessions on Zoom. So this was all over. Let's talk during the pandemic. Let's talk that. Let's talk what people were doing during the pandemic. All right, because that's a great example. Because that's evidence right there. I'm using during the pandemic, which was and that people were meeting on Zoom for over a year and a half. Schools, students and everything. They weren't even going to buildings. Nobody was going to buildings. Nobody was going to work site buildings. They were still working. No children, students were not going to buildings. My daughter was not going. My daughter was in her room all day. My daughter's in her room all day. You know, she didn't leave the house. My daughter didn't leave the house to go to a building. She was in her room all day. So I'm just, these things happen. So what I'm saying is Zoom is a great meeting place, evidenced by what occurred all throughout 2020, even into 2021, where people think that things that they didn't think they could do, they did. We continued, we never stopped classes. We had 120 people, the first class. What was that, 10, 120 something like students, the first class. Second, had over 120 something the second class on Zoom. And we only had what, five, six in the building. So I hear what you're saying, because when I hear people talk, I analyze. I mean, I don't just sit there and just listen dumbfoundedly, you know. When people talk, I'm analyzing what they're saying. I'm measuring what they're saying. So I hear you say building. So I'm measuring what you're saying. So, well, during the pandemic, 2020, people weren't going to buildings. And they still got done. I mean, I'm just saying. You know?
Yeah, I get that. But what I'm saying, I'm just speaking from locality.
Yeah, I'm using something that actually happened. I mean, I'm not even making these things actually happen. So I gotta use something, things that actually happen to make my point.
That's definitely important for state to state meetings.
Elkanan.
Can barely hear you. Your mic is covered or something.
Oh, is okay. Can you hear me now?
There you are.
All right. Yeah. Just to add to that point, Abdullah, I mean, you know, I understand what the brother is saying as far as having a building in order to make it more people to commit. I'm 50-50 on that, because for the last, minus the summertime, for the past 2 years, my whole school, my whole network has been on Zoom. That's how we've been meeting. We've been meeting on Zoom since 2019, or really right at about 2019, 2020, all the way up to 2021. So we put in a good 2 years, a fresh 2 years. The lodge at the same time, the lodge and a whole network of lodges, over maybe 1,000 lodges, met on Zoom, classes on Zoom. Matter of fact, classes that I was doing with you, Abdullah, we were dealing with classes online with Zoom.
Yeah, you and I were doing Zoom. Yeah.
Yeah, on Zoom. Yeah, all that. This is all in the past 2 years. Everything was done. Everything. The mosque was all meeting on Zoom. Classes.
Certain funerals could be viewed on Zoom.
Yeah. Lodge meetings, classes, mosque meetings. I mean, everything was everything was online.
I mean, everything.
Yeah, people found a new way to do business, you know.
They sure did. That's my whole point. That right there was a new way, because I mean that was not done like that. Not in that mass numbers. Not with, I mean, you're talking about everybody, every entity, every schools, every different corporations and stuff. Workers worked at home. I mean, this was, you're talking about millions of people literally on a daily basis on Zoom and with other outlets they had. Millions daily. Literally millions daily. I mean, Zoom's what's it platform portfolio increased.
Not only that, but the so many millionaires were made in the last 2 years from doing Zoom meetings. Now, I'm not talking about starting at scratch, but let's say you were probably doing something like $200,000 a year. Now you just increased 80% and you're at $1 million. So a lot of things was happening. A lot of things was happening in this pandemic. And the pandemic forced us to stay at home, and people had to fight for their livelihoods, livelihoods.
Sure.
So businesses that were overseas, that were American businesses that were getting taxed and things of that nature, they did so much. A lot of people who already had skin in the game made millions. So yeah, yeah, it's and so many organizations were created during this time in the past 2 years because of Zoom. Yeah, Zoom increased. I don't know what their shares went to, but they went up. Their value went
Of
up.
course they will. Absolutely. 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 All right.
Do we have any questions regarding the presentation? We have about half hour to
slow
go.
walk this. Any question regarding the presentation? Thank you, Terrence. Yeah, we definitely gonna slow walk this because there's a lot of material we have to cover, and we're gonna be taking our time with it. This is a part 1 review. I think it's a pretty good review. You know, I wanted to make some points of preventing the stop. We can make that happen. It's just knowing how to do it. I mean, this is why we're here.
And not to mention that the questions that we're going through, I mean, we've been through these questions before. Is just that the last class, without even asking the question, Shim had answered like each one of them. So, that's why we're, just slow walking it, slow the train down. We got to slow Shim down sometimes and just go through each point and, make a point of each point. So that way we all digest, in a good way. So any questions pertaining to the presentation for tonight? Because we will also continue until we're done the rest of the 28 slides. So we're only on slide 7 right now. So
yeah, we got, we'll do next week. We got next 4 more weeks. We'll do this. The need be. We got a couple plans on.
Okay, Quentin L. You have the floor. All right, looks like he put his hand down. All right, Brother S. Murray Bay, you have the floor.
Islam, I just had a question. How can I get a hold of this transcript, or Abdullah?
Yes.
I had the same question.
I have your number, right? Did you text me?
Yes, I did.
I'll send it out tonight, maybe tomorrow morning to you. I'm sending out some tonight, tomorrow.
Islam, peace. Peace.
Uploaded, and about have done it to about 11 o'clock. I might be too tired. All right, so I'm saying tomorrow. I'll text it out to you. All right. Those whose numbers I don't have EPM. Text me 215-300-5471. Text me your name and number, EPM. I have Murray. Some people went off. Left. I don't see. Oh yeah, we lost some people. Moorish Science Temple 4 in Indianapolis. I have yours, right? You got you have my number and you text me?
Yeah, we communicate.
All right, good. All right, so others I didn't. Yeah, there's people that jumped off. I didn't get a chance. Shag Dog, Ujama Tribe, Youthy. Did I get Youthy? Yeah, we got from people that jumped off. All right, Quentin, I have yours. SA. All right, good. All right, go ahead. We have another question?
Yeah, I had that same question. How do we get a copy of that transcript?
You have my, 215-300-5471. Text me your name and number. 215-300-5471. Text me your name and number. That's my number. You're gonna text me. All right.
Also,
It's gonna be
also
on you.
this-
It's also
this-
be on our Moroccan Post News, Moroccan Post
Moroccan Post
News
Media.
YouTube page.
It's going to be Moroccan Post Media YouTube
Right,
page.
Terrence.
This is going to be each one of our classes are going to be uploaded. You know, right after we get off, as soon as the video becomes available. I think it takes maybe about 3 to
Amanda
5
already
minutes.
put it up there. Amanda put it.
Oh, good, great. So yes, so this is what
Amanda
it is.
put the YouTube link.
Now, not to be confused with Moroccan Post. Moroccan Post, yes, that's us as well. We only have a few videos on there, and we don't have the access to Moroccan Post. So therefore we have Moroccan Post Media. That YouTube page is not completed being built out, but we do have about probably almost 20 videos on there. And so all of our classes that we're doing now, that's going to be uploaded every Wednesday. In fact, next month, just want to inform everyone, we're going to go to every other Wednesday.
Every second and fourth Wednesday.
Every second and fourth Wednesday. So, yeah, we just want to get the content up and then, you know, get it on the YouTube page. So anyway, just
and furthermore, Amanda put the YouTube link in the chat. The YouTube link is in the chat. That YouTube link will take you to Moroccan Post Media. That this class will be uploaded tonight.
And I want to say something. All my moves, all the grand seasons that Temple to be here. I'm glad to be able to talk with y'all today. I'm glad we all part of the number. We're all part family. But love for all of y'all.
All right, so we want to continue. Can we continue?
Sure.
All right.
Oh, what do you want up there? The
next page. The next page. Whatever.
Okay.
Where Amanda left off.
Okay, I'm gonna switch it back over. Okay. I believe this is. Oh, it's up. Oh shoot! Here it is. This is it. Was this it? I think that was it.
Yes. Why council? Is that it? Why council is important? Is that where you left off, Amanda?
I can't see it.
Okay, hold on. Let me make sure. Hold on. I'm going
That
to...
sounds right. It looks like it's the same place.
All right. So that's a question. Why council is important? Why is a council very important?
Okay.
That's the question that Shim asked. Shim asked that question last week, and he went into explaining. So why is the council very important? Shim Malachi Bey.
Should I read this or is Shem?
Yeah, you can read it. He had Shim.
Why is the consul very important? A treaty vests power in a consul. Vienna Convention of Consular Relations. The United States Congress ratified this convention. Consular notification. 22 U.S. Code subchapter 19 Privileges and Immunities of International Organization. 288A Privileges, Exemptions, and Immunities of International Organizations. Code of Federal Regulations, CFR. The Code of Federal Regulations is the codification of the federal government's rules and regulations published in the Federal Register. 28 CFR 50.5, notification of consular officers upon the arrest of foreign nationals. A, this statement is designed to establish a uniform procedure for consular notification where nationals of foreign countries are arrested by officers of this department on charges of criminal violations. It conforms to practice under international law and in particular implements obligations undertaken by the United States pursuant to treaties with respect to the arrest and detention of foreign nationals. Some of the treaties obligate the United States to notify the consular officer only upon the demand or request of the arrested foreign national. On the other hand, some of the treaties require notifying the consul of the arrest of a foreign national, whether or not the arrested person requests such notification. Number one, in every case in which a foreign national is arrested, the arresting officer shall inform the foreign national that his consul will be advised of his arrest unless he does not wish such notification to be given. If the foreign national does not wish to have his consul notified, the arresting officer shall also inform him that in the event there is a treaty in force between the United States and his country which requires such notification, his consul must be notified regardless of his wishes, and if such is the case, he will be advised of such notification by the U.S. Attorney. Consular Notification and Access Manual, United States Department of State, 5th edition, September 2018. Arresting a non-United States citizen, consular notification process. Are you a national of one of these countries? A list of countries are given in the manual. Consular notification to the Office of International Affairs in the United States Justice Department. Rules of evidence under the consul seal, writ of assistance, United Nations Human Bill of Rights. The United States cannot prevent the native Moorish to establish indigenous governments.
Moment there, Shem.
Yes,
Shem.
yes,
All right,
yes.
so I want you to elaborate on this point.
Let me explain something. When the United States signed the human rights.
Put your video on. Put your video on.
All right, give me a minute. When the United States signed the human rights bill, the human Bill of Rights, in that Bill of Rights, no nation can stop a people from forming government in their own country, in their own jurisdiction. So Moors, when they form government, the government structure, the council will force that. The council had a right to force that Bill of Rights. And by the president signing and Congress ratifying it, they become a party. Now, Morocco is the hosting nation, the signed with Great Britain, France, Spain, and Denmark, Sweden, Dutch. And because Morocco is a hosting nation, and they signed all of signing Algiers, all these nations signed to protect Morocco and signed Algiers, and France being to protect Morocco. These are signers to the instruments. Therefore, your council can force these instruments not only to the United States organization, but to the Council General of these sovereign powers, the Great Britain. And what happened is, we just got to get the Moorish government together, a national government together, an association of Moorish states, and do what we got to do. That's all it comes down to. The Spirit set the power of the unseen world. The Spirit set up the groundwork through us. All we got to do is go along with the groundwork that was set up for us. This is already set up for us by the unseen world. All we got to do is go with it and come together as a community, a congregation, which is a community, a society, and form government. And when we do that, we get to appoint our own council officers, our own judge consultants to represent us. As a matter of fact, we even come in and take an attorney of the state, a bar attorney, and we can go ahead and get a bar attorney license to work for us. And believe me, licensed attorneys on the American Bar Association have rights to represent foreign nationals and represent treaties and conventions on international law. The foreign nation, the hosting nation, got a right to hire license that bar attorney to work for them as a jurist, and an attorney only can represent international law for that. See, it's a lot we can do. It's a whole lot. Any questions?
Any questions, y'all? Any questions? Well, we have about 15 minutes before we close.
Yeah.
Islam. This is Shin. This is Brother Shin.
Yeah.
How are you doing?
Peace.
Peace, Shin.
Yes.
Yes.
Where did the I had a question. Where did the Sultan come in all of this? And I know the government we would institute would be provisional. Where did the Sultan fall into? Did the people the inherent power is still in the people, or because of the Sultanate? What was the difference between how we would be doing things and what was done
let me
then?
let me answer that. Let me answer that for you. First of all, the Sultan was the one that beat the Roman Empire out, the Pope, Constantinople. When the Sultan beat them out, they took over all the vested empire of the Roman states, which is France, the Phoenician land, Spain, Great Britain, England, Denmark, and also African and the African domains. The Sultans took that over, but in 1912, the Sultans gave up his authority. Yes, he did. Read the Treaty of Fez Treaty. I got the history on it. So anybody know the Sultans gave it up. When the Sultans gave it that authority, what the Sultans did, put that in the hands of France, the Republic of France. And France is a treaty nation with Morocco. So when he did that, it left the Moors in a situation to run provincial government now. So now France is the protector of Morocco. Now I'm gonna give you an example. When the French Moroccans under Islam, the doctrine of Muhammad, they claim to be a state, sovereign state, independent of what? Independent of France. I mean, they was not a subject to France, so they followed the Constitution, formed a community, a political body based on international law, a permanent residence. What happened was they called themselves the Kingdom of Morocco, and therefore the extended territory of Morocco went into Africa. So therefore, the part of extended territory of Morocco and Africa, that the territory became a permanent domain, dwelling place, permanent domicile. So I'll bring it down, give you an example. The Sultan gave up his right. He said that France was his successor. What happened was under Fez Treaty, the Sultans took and borrowed money to live luxury and put itself in debt with the bankers, international bankers, hear me out, and placed that burden on Morocco, but Morocco's subjects, the Moors, to pay back them debts, notes that he borrowed. So you can see it was just the European powers having the Moors on the conquest. The Sultans had the Moors on the conquest too. Yes, he did. Nobody want to tell a secret. I'm gonna tell it. Yes, the Sultans had the Moors on the conquest too. That's why the Moors got into a bad situation, because what the Sultans was doing with the European powers. The Sultans gave, listen to me, read the Treaty of Fez, it's in there. The next time we have our next meeting, we're gonna draw the Treaty of Fez and show you the Sultan pointed at Morocco, the French Republic as the successor in Morocco. What that mean? That means he gave up his right. When you put somebody as your successor, that means you're next in line. So France stepped in next in line as a protector throughout all Morocco. This is how they could beat the United States, because they had a superior seat now. They said we in the stead of the Sultans in Morocco. So we the more favored nation. So therefore, when that happened, when you hear the ruling emperor say that my successor is the governor of a foreign nation, that means they step in that nation in a French zone. So the whole Morocco became a French zone. Although Great Britain, Spain had a Spanish zone and a British zone, but France became the dominant power because the Sultans gave legal authority over to French government. So I got the history of that. We're gonna read that next time we get on. We're gonna read that. So the Sultans relinquished that authority he had in Morocco and gave it to the French government. Therefore, the Moors now, when they do finish dealing with European powers, they can use treaties, but they can use the Fez Treaty is very important. The next time we had it, we're gonna put the Fez Treaty up and read it. When it was the successor, the Sultan of Morocco appointed the French government as his successor. Why? Because of money, borrowing notes. He made a Moor the guarantor, surety for the rich bankers, European bankers. Yes, it's in the treaty. Yes, it is. It's inside the treaty. And they supposed to help us with our banking. The French government, the Spanish government, all are obligated to help us with our banking, help us set up our police. That's why the Justice Department, they got Ninipol. Now, I'm going to tell you Ninipol is. They don't tell you this. Ninipol is a foreign army that comes in to help the indigenous people when they're being oppressed. You have to file a notice and summon them to that foreign organization. It's a notice got to be filed. Council notice got to summon them to protect the Moors. So we can sell a government raid. We can do that.
So
Any more questions?
Shim answering the question, why is the consul is important? He's answering that. He's doing a great job. Why is government structure important? He's answering that. Why is Moore's government structure important? Why is Moore's consul important? He's answering that. This is important that we continue to stay on this, because this enforce the Constitution is individual process. This has not been the tone. This has been the tone since April 2019, but you know, this tone was slow moving because we were in development, you know, putting together the structure, putting together curriculum, educational structure, CASES. All right. So we've been, this has been just like a crescendo. This is a crescendo. All right. This is building. This is building. As I continue to reach out in El Canan, we continue to reach out to our contacts and so forth. This is a crescendo. It's building. All right. I told Shim, it's funny with where he is right now, right outside, where he is now, April 2019, that this will be a crescendo. All right. This will be a snowball effect.
S. Murray Bay has his hand up in the chat.
Islam, I just want to know, the brother Shim, did he say Interpol? Did he say Interpol?
Yeah, Interpol.
Okay, Interpol.
Yeah, yes, he did. Interpol.
Okay.
Yeah,
Thanks,
INTERPOL. 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 Yes.
It's an international police force that's set up by the international body that do international policing to protect nations from other nations that try to violate the UN Charter and UN Convention and treaties. They supposed to come in and set that nation up. I'm gonna show you, I'm gonna give a prime example. When the United States go to side nations, they operate as Interpol. What they do is go inside nations, set the police, so the nations have set police and protect themselves. That's Interpol. See, the key thing is not letting the more know who they are and not create government. The moment they create government, they can exercise all their political channels and diplomatic affairs, government-to-government relationship. Not one individual claiming that. One individual can't protect his house by himself with the army coming. He need a host of people to help him out. Strategy is the main thing. When you got a government, the strategy part is one, because you came together. The strategy part is to know you're in danger. How Tzu wrote a book, The Art of War. He said he doesn't know an enemy should lose in every war. You got to know your enemy is. The first enemy is yourself, not know who you are. You stay in that mind frame, not knowing you are, what you can do, and being afraid. You never can beat your enemy because you know who your enemy are. Once you find out who your enemy are, you can win out. You can fight the battle on an even, full pace with knowledge. There got to be a plan. The plan is know who we are and what we can do by who we are. Once you do that, we follow international guidelines and do what we have to do. All is extreme walking from there. We know we have a bunch of abuses with some people that don't want to fall in with government structure because they want to be a sultan or a pharaoh themselves. I've seen that before. So-called proclaimed sultans and pharaohs want to control the people for money. We can't let that happen to our children, our baby. We can't let another Moor put us in another 50 or 100 years of conquest that we're coming out of. We can't do that. We gotta have a monarchy government of the people, for the people, by the people, by the Moors. Of the Moors, by the Moors, and for the Moors, period. Not of one house, of one family, of one kinship heir, and that's it. No, we can't do that. Because we realize that no kind of government fell. So one of the things we're gonna bring up next meeting is the Feds treaty. We got to be it for ourselves. You asked the question about where's the Sultan play a part in this. I tell you where he played a part in this. He played a part in this, signing over the Morocco authority to the French government. And when he did that, the French became protected in Morocco. So we got to get government-to-government relationship together so we get a unity, not with the central authority, but with the French government. Because the French government can step in, intervene, and stop everything based on a treaty. We the one that's in they invoke the treaty and said we are the one in the treaty that would make the successor in the place of the Sultan. Therefore, the Moors are under the protection of the French Republic. What that means, when the council come in and decide something, it got to be decided by the laws of the French government. Yes, it does. Read the treaty, it's agreement. I didn't make it, I wasn't born back then. But it's agreement, it's a fast treaty. We need to read that, it's very important. I get Abdullah some history on how I got that way. The Moors turned on each other. See, Moors are turning on each other. I got all the history how they would fight each other, turn on each other, taking over each other's territory, letting the Europeans take more ground. There's a lot happened to this. It was the European conquest. The Abdullah said, we not weak people. This ain't just happen by itself. We contribute, our ancestors contribute to a lot of stuff themselves by warring and going against each other.
All right.
Any more questions?
Any other questions? We got what, 5 more minutes? Any questions? You want to fill in a couple more questions? All right.
All right, that's
Thanks,
very
brother.
Islam, Brother Shem, didn't France give up jurisdiction in Morocco though?
No, the United States did. Abdullah got the laws on that too. CFR, United States, relinquish jurisdiction in Morocco. Let me explain what that means. When United States relinquish jurisdiction in Morocco, United States falls under the protection of the French treaties they have with France. Oh yes, United States signed a treaty with France and Great Britain. All the European powers, United States follow their protection. They wasn't protection in Morocco, not no more than the protection of the French government. They won't say it. They won't teach us. They won't teach their own citizens. Why? It's all about brainwash. Then they get the language. They create the language and created the language and stories and journalists to create a fraud through the media and language will create through language a fraud. That's what's going on. A major fraud.
Let me make this point here. I read something earlier, and I think I sent it to you too. I made a snapshot of it in a book that Shem sent me on extraterritorial consular jurisdiction, the original meaning and application of extraterritorial consular jurisdiction. Book that you sent me 2 years ago, Shem. And there's a section in there that reads that based on epistemological basis that you cannot use a modern construct to analyze something that's ancient or 200 or 300, 400 years ago. I mean that. All right. But what I'm getting to, Brother Mansa on Moroccan Post on Come TV on Sunday made a great point. When people say Morocco, what they're doing is analyzing. They'll read the treaty. They'll read the treaties that I have in Moors and Masonry. Meaning and they'll look at these modern European land boundary survey session maps, and they say, "Oh, Morocco." So what they're doing is analyzing the Moorish treaties 300, 400 years ago, and looking at these modern survey maps. Oh, that's Morocco. No, you're not. Where Morocco, the Moroccan Empire, and also, furthermore, the Kingdom of Morocco, the treaties between France and Emperor Morocco, England, Emperor Morocco, that was not signed under the authority of a king. It was not, those treaties were not signed under the authority of a king, of an emperor, but not a king. We got to kill this Kingdom of Morocco. We got to kill that. misconception. Show me in the treaties that I have in Moors and Masonry where those treaties were signed under the authority of a king, a Moorish king. Where's the Moorish king at in those treaties?
Yep.
No, this is Master made some great points, and that you're analyzing the limits. You're limiting the geography of Morocco. You're limiting just that little teeny peeny area, you know what I mean, in North Africa. That little, that's an error. All right, so we got 3 minutes. Terrence, you want to wrap it up?
Sure thing here. I'm going to switch over to, let me put a spotlight on this right here. And you can talk about this here, Abdullah. Let me remove you real quick. And Shim. Here you are, Abdullah. Can you see that?
Yes, Moors and Masonry Part 1. You go to moorsandmasonry.org.
Right.
This is Moors Masonry. This Moors Masonry Part 1 lays out the historical foundation for Moors and Masonry Part 2. Lays out the historical foundation for Moors and Masonry Part 2, the power of Moorish treaties, and the recovery of lost Moorish sovereignty. So I lay out the historical foundation. And this is why you see I continue to reference the treaties that I have in Moors and Masonry. Because I'm laying out the historical foundation, the tremendous sea power of the Moroccan Empire and her dominions. Because you read in the treaties, it was reference to the empire and throughout her dominions, even with Great Britain, throughout her dominions.
Right.
So we have to expand our knowledge base. This is Moors and Masonry Part 2. If you want to pre-order Moors and Masonry Part 2, go to moorsandmasonry.org. I have to put up the old book cover is still on there. I'll be putting up this new book cover next week. But you still can go to moorsandmasonry.org to order Part 2. The pre-order. It's coming your way November.
All right. Once again, this is going to be posted on YouTube for every class. The next class will be on the 7th. So right now for this month coming in, it's going to be every Wednesday. So the next one is on the 7th, and that's going to be Moorish Treaty. The topic is same topic: Moorish Treaty Protection and Consular Relations.
Same
part
topic.
3.
Absolutely.
Same topic. It's just going to be part 3 because we're gonna slow walk it here.
Yeah, we're gonna stay, absolutely.
And so yeah, that's off now. That's all we have for now.
Now, once again, the Zoom link is in the chat, but I'll still, like I said, I do have numbers. We have me. Can you text me your number? Text me your name and number. My number is 215-300-5471. My number is 215-300-5471. Text me your name and number. And I can put you down. I got you down as me. I have everyone that came on tonight. We had 27 that came on. All right. And also also share the link on your social media platforms. Share the YouTube link. As you get the YouTube link, share the YouTube link. This night's class as well as last week's class. All right. On your social media, Instagram or Facebook page. All right, most likely your Facebook page and so forth. Share it. All right, and also invite other people to the class. Share the Zoom link to others and invite them to the class. Let them, and also share the Zoom link to them, co-workers and so forth, your kinfolks and friends and neighbors and so forth, and your social media platform. All right. Continue to share it, and we'll see y'all next week. All right, same bad time, same bad channel, 7 p.m. Eastern Standard Time. All right. Thank you all for joining us.
All right.
Thank you.
Peace and love.
Love.
Peace to the Moors.
Peace, peace, peace.
Peace.
Thank you for your time, everybody.
Yes. Peace and
Thank
love
you.
to all more scientists with grand sheets, all the visitors. Much love. Cinematic got paid. Love all of y'all.
All right. Islam, brother.
Islam.